Okay, I'll just welcome, since we're recording. Hello, everybody. We'll start in a minute, the actual presentation, but just to welcome you to this, what date is it? The 26th? This Friday, the end of the month, in September, our monthly HRUG-Open meeting, Human Rights Universal and Global, hosted by, as you can see in the background of Professor Herman's logo, the Central South University, the Human Rights Center, Central South University in Changsha in China. And we're just waiting for hopefully a few more attendees. So I will hold off just a minute just to anticipate where we have a presentation today on the legislation and implementation of workplace sexual harassment laws legislation in China, presented by Dr. Guo Min from the law school in Central South University, in fact. So I should introduce myself as well, Joe Finnerty from University College Cork. Welcome everybody, as I said a few minutes ago, to this September Friday session of the HRUG Human Rights Universal Global Open Talk. As you know, the HRUG-Open talks are hosted by the Human Rights Center in Central South University, associated with the law school there. And today we are delighted to welcome Dr. Guo Min from the law school in Central South University, whose presentation is entitled, that I have in front of me, Legal Progress Without Judicial Change, Understanding the Limits of Workplace Sexual Harassment Protections in China. And for those of you unfamiliar with these monthly presentations, the format is the guest speaker presents for, well, as long as they want, really, but sometimes it's 15-20 minutes perhaps, and then we open the discussion to comments, questions, observations, and so on. So to start, then, I'm going to invite first of all, to say very warm welcome to Dr. Guo Min, and I invite you to present. Thank you.
Thank you, Prof. Joe. Now I will share. Introduce myself. My name is Guo Min, and now I am post PhD in Central South University. And today my topic is about the workplace sexual harassment in China. Well, we all know that the sexual harassment is a serious issue in many countries, including China. Many scholars describe it as unwanted sexual behavior that workplace uncomfortable or unsafe. Studies in China show that almost 1/3 of women have faced this problem. In recent years, China has many new laws, and many new laws have been made to protect workers. But the laws alone are not enough. But the laws alone are not enough. The key question is how the courts explain and use these laws in real cases. And that's what I want to explore. Now let me explain how my talk is organized. My presentation has 4 parts. First, I will explain the theories behind sexual harassment. Second, I will show the development of Chinese law from 2005 to the 2021 Civil Code. Third, I will share the result of my case study, which look at real court judgment. Finally, I will point out the main problems in how judges handle these cases. Let me begin with the theoretical background. Here, I use two main theories about sexual harassment. These two are the most representative, and they also support my study best. The first one is power hierarchies. We all know that sexual harassment is closely linked to power relations. In workplace, people in higher position may take advantage of those in weaker position, such as bosses over workers. And the second one is sexual harassment as gender discrimination. The sexual harassment should not be seen just only as an individual conflict. It shows a wider problem of gender inequality. When harassment becomes normal, it keeps women in a lower position at work. So in this sense, sexual harassment is not only a personal act, but also a systematic form of gender discrimination. The second theory is especially important for my study. In my later finding, I saw that many problems in China's courts come from the fact that the judges do not treat sexual harassment as gender discrimination. This is the key reason why legal systematic has many weaknesses in practice. So with these theories in mind, let's look at how the law has developed in China. China's laws have changed step by step. In 2005, the law on protection of women's rights and interests first used the term sexual harassment. We can see that the Article 40 states sexual harassment against the women is prohibited. It's simple and it gives no clear definition or remedies about it. The later laws made some progress, but this situation continued until 2020. The Civil Code 2021, it gave a clear rule. It not only banned sexual harassment, but also required employers to take action to prevent it. The article also made clear that men as well as women can be victims. Because we can see the 2005, only the women can be the victim of sexual harassment. Many scholars see this 2021 Civil Code as a big step, but its real effect depends on how courts use it. So how do courts actually deal with these cases? Let's look at the data. I studied the cases from Peking University Law Database. At first, I found more than 1,000 cases using sexual harassment as a keyword. But after removing unrelated ones, only 188 cases really involved sexual harassment. Out of this, 102 cases were about workplace. This number is quite small compared to the size of the problem. It shows that only a few victims choose to go to court, and legal changes have not been brought many cases into system. And there's another interesting thing is that it is about the plaintiff. You might expect most of them to be victim of sexual harassment. That's because the victims go to the court for to ask the protection or compensation. But in fact, this is not the case. The majority of this lawsuit was started not by the victim, but the people accused of harassment. They go to court not to deny the behavior itself, but mainly to argue against their dismissal by the company. In other words, instead of victims using the law to seek justice, it is often the alleged harassers who are turning to the court to protect their jobs. And it sounds a little bit amazing, right? But that is the truth. Now, let's see what the problem appear in these cases. One big problem is that the judges avoid using the words sexual harassment. Even when the victims or companies using this term, the courts often replace it with misconduct, with bad behavior, or just use the word harassment. For example, in one case, a female employee accused a male harassment. But the judge described the act as a male colleague touching a female colleague's body without reason. They didn't use the term sexual harassment, so it's overlooking the sexual nature of this act and making it harder to address it directly. Besides the language, another big issue is evidence. On the one hand, the judges do not believe victims' stories. After 102 workplace cases, there are 39 cases were rejected due to lack of evidence. A famous feminist scholar, McKenna, noted that it typically took 3 to 4 women testify that they had been violated by the same man in the same way. And on the other hand, the court don't believe the employer's evidence either. The court and the employer have 2 different standards. Inside companies, witness statements or internal checks are often enough to confirm there is the sexual harassment happened. But in court, judges usually ask for stronger evidence like text messages, recordings, or physical proof. This makes it very hard for victims to succeed because sexual harassment often happens in private without witness. And another problem is about the role of employer in these cases. Many scholars say Article 10 of the Civil Code was seen as a real progress because for the first time it clearly said the employer have a duty to prevent and stop sexual harassment in workplace. In theory, this means not only the individual but the company should take responsibility. But in practice, courts do not always follow this idea. In a JD case, a female employee said her boss had harassed her. She decided to sue both her boss and the company because she thinks that the company didn't take any measures to prevent her. But when it came to the company, the judges said a company cannot harass because the harassment can only act by a real man. The company is not a neutral person, so they refuse to see the company as a defendant. We can see this way of thinking creates a big gap. The civil code clearly tells employer to prevent harassment, but the court's judgment made that duty almost meaningless. In the end, the company had no real legal responsibility, even though the law said it should. And this problem is also connected to how companies handle prevention. In practice, many companies have no clear rules, no training, and no complaint system. When a complaint happens, they usually just fire the accused worker. Court also do not ask if the company had done prevention work, so the companies can just ignore the prevention without facing legal risk. This is a serious weakness in this system. And in most workplace cases, the only action taken is just the dismissal. Out of 102 cases, about 70 cases involved a worker being fired for harassment. Once court believe sexual harassment happened, they almost just always agree that the dismissal is legal. Judges do not usually ask if the punishment is fair or too harsh, or if other measures were possible. This shows that the courts focus only on firing the harasser and not on broader solutions. Finally, let me conclude my findings. From these cases, we can see that current judicial practice in China shows several problems. And the court, they just treat sexual harassment as a personal behavior instead of a workplace issue. So that's why the courts often avoid use the term sexual harassment, and they demand very high level of evidence, and the employers are really held responsible for prevention. And these problems make the law less effective in practice. Here, I try to suggest several possible ways that might help solve the problem. It's including shifting in perspective and employer accountability and so on. But a long way to solve this issue. And okay, that's all. Thank you.
Okay, that was Dr. Guo Min. Thank you very much for that very interesting presentation about aspects of workplace sexual harassment and the law and the courts in China. Very wide-ranging discussion, lots of interesting points. So I'm going to open the discussion to attendees. If you want to raise your hand or just come in. So please feel free, anyone, to ask questions or make a comment or seek clarifications. Okay. Peter.
Yeah, a technical question or just information. that's work-related. Are there any figures on non-work-related harassment?
Sorry, Peter?
Well, you have been talking about sexual harassment workplaces.
Yeah.
Is there any information that it's happening outside of some figures? How often, or what is the situation there? Not least at home.
Oh, well, yeah, I just made some work on the workplace sexual harassment, and there are also many other types of harassment, maybe in schools or even in between strangers. But I think the workplace is one of the most important type because it shows the power. It shows the power. High risk. Yeah. So I just make this. I just trying to figure out this question.
Well, the reason for asking it is if I know it's kind of observed in the working environment, so I could escape this and say outside I'm kind of free, nobody bothers, and I remain undetected because I know in European countries most of the assaults are actually happening at home in the family. So it could be interesting to know what are the incidences at home.
I have no idea. Home harassment. You mean between the family or?
It's in the family. It's often by actually by people who know each other, where it's kind of considered to be, well, not a serious incident, but it's about family relationships or whatsoever, and that's extremely difficult then for the women to go to the public, because what you said, even there in the workplace, it's not really recognized. So in the family, it's probably even less. A kind of, yeah, do whatever you want.
I think it's a very interesting and important issue. I think I will try to explore it in the future.
And that's, if I may make a comment, that's a typical example of a question that speakers get asked, not about what you presented on, but about other issues that you didn't present on. So there you go.
No, it's related.
Of course, yes, I know, but not relevant directly. Yeah, thank you. Okay, any other comments or questions? I have a question, if that's okay. Well, I have a few questions, but one question is in the cases that you discussed, one distinction is between women bringing cases of claims of sexual harassment against, I guess, fellow employees, often their bosses or superiors in the workplace, in their workplace. But the second category of legal case was about appeals by employees who had been dismissed, typically due to firms deciding that are claiming that are judging that the employee had engaged in sexual harassment of a female colleague, typically a junior or subordinate colleague. So there's two different classes of cases. So maybe you mentioned this in your presentation, but there's kind of two different types of they're quite possibly quite different cases or types of case. One refers to an appeal against a firm. So a defendant in that case is the employer, whereas in the case where the woman is making a claim against a fellow employee, the defendant is an individual. And obviously an appeal is different from a claim in the first instance. So it's and my comment, I suppose, is they're kind of quite different in those respects. There are quite different types of case.
Yeah, it's different. When I search these cases, I just use sexual harassment as a keyword
Yes.
in the database. So all the related cases, including the women, include started by the women or and started by the employee who are fired by their company, and all of the cases are here. And then I just read the case one by one and select which cases are not related and which cases are related to workplace. So there are two different types in my study.
Yes.
Yeah.
Thank you.
Thank you. So I think it's also the first time for me to learn a lot about this topic. Since you mentioned that in your conclusion concerning about strength and education, right, for the gender sensitivity and also the complicity of the harassment. So do you have some ideas, for example, how could we make this education, for the young people or even the kids, for example, to make it for prevention, for example?
Well, I think in our reality, or now we can see many men, they really don't see their behavior as harassment. Maybe they just think it's just a joke or a normal interaction. But if we can, this shows why prevention is so important and why education is important. If we can give some education or give some lessons in the kids, in the children's school, and they can know the rules is, and they can have regular training, and they can for the male children, they can know when they grow up, they can know what the boundary is, and for the little girls, they can know that is the bad behavior, and I can when I face this situation, I will try to report it, not just be silent. I think this is important.
Yeah, thank you very much for the sharing.
Yeah, thank you.
Sure.
Yeah. So is that me?
Yeah.
Yeah, it's weird that yeah. It's weird that the internet today and is really poor, and also the connections. And I hope you can hear me clearly. So
yes.
Yeah, good. And thanks, Guo Min. And I have two questions regarding the 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 employer's obligation, and this is very interesting. Could you clarify? Is there any like laws and the regulations providing the detailed, the detailed regulation on the employee's obligation? Because when you are doing when you showcase the results of the cases, and you emphasized that the employee actually they did not fulfill the legal obligations in terms of like providing the preventive measures. And I was wondering, because this has been stipulated by the civil code, and is there any further regulations? So this is my first question. And so the second question is, could you also clarify that in terms of the employee, what kind of obligation do you think the employee should fulfill? And okay, let me express it in another way. So, what is the borderline of the legal obligations that employee should fulfill? So after you finished this article, in your mind.
Yeah, okay. Thank you for your question. And for the first question, I know after the civil code, there's still no. Oh, let me check. Yeah, after the civil code, various government departments in China have issued regulations to clarify and supplement the civil code, but all the clarify and all the reference text now they just offer recommendations and the best practice for the companies, but all the laws are not carry the force of law. Therefore, why these guidelines, and also maybe we shouldn't call it law. It's just a reference or guidelines. So although it's important, but there's no force enough. And this is the first question. And for the second question, you see the employees boundary, right? Or employees obligation. But I don't. For me, maybe I think the more obligation or the core issue is still employer, not the employee. But for the employee, you just don't behave or don't do that sexual harassment to others. But for employer, when we talk about the victims or awareness, in the end, the workplace need clear rules and systematic system. If the employer take real action, maybe including training or complete channels, and also prevention, then many of these problems can be reduced, I think.
Oh, thank you. Yeah. Sorry, I needed to do. I needed to state a correction. Yeah, it's the employer's obligation. Yeah. Sorry. Yeah. Okay. Thank you. Thanks for your answer.
Thank you.
Okay. Can I ask another question? Guo, just a brief question. Maybe you mentioned this, I'm not sure that you did, in relation to judges and the I think one of your recommendations was about strengthening judicial kind of training and the culture of judges, you might say. But my question is, my question is about the gender of judges. Are judges in the cases that you looked at, do you have any data on whether they were predominantly male? Were there many female judges in the cases that you examined?
This is a very important question. In my study, I only found one case is about a male victim, and because I don't know, or I have no access to the gender of the judge, so I'm not sure how many male or female judges in this system, or how many, or the differences between the male or female judges when they handle the cases. But I do find one case. There's just one case from 2000. From 2000 to 20, I think 2023. Yeah, just one case. I think maybe the problem is that compared with the female victim, the male victim is often invisible because maybe they feel embarrassed to report, or they may feel fear people will laughing them, or the people will don't believe them, and in some cases, maybe the society they just have some they don't taking their complaint seriously. They just laugh at them, and this means when I think the law and the cons should treat the male victims equally, not only just protect women. And yeah, that's my opinion.
Yeah, and just thank you. And just to say, obviously, the professionals are mainly would have presumably for the type of training and
yeah,
the type of training that one would recommend for judges. I think there's some other interference coming in there. Has someone got their...
Also Donald Trump setzt Präzedenzfälle, die ja genauso auch von einem demokratischen Präsident in der Zukunft genutzt werden.
That's German. Peter, have you got something on?
Yeah, that was the famous Handelsblatt comment. Okay.
No, sorry, my point was that if, to the extent that the judges in China, the judiciary are predominantly male, that would have implications for the type of training and education in the future. Perhaps, yeah. Thank you.
Just briefly, okay. Explanation on this, why they switched on in the background. I have to upgrade for whatever reason. So we have currently 7 minutes left, because I cannot upgrade while we are talking.
Okay. Yeah.
All we have to do
is forgive you this time. Yes.
I would have another question linking actually this. The one thing is the education, the other is this threshold. in concrete terms, what does it cost actually not to fill the obligations? Not if the enterprise doesn't observe sufficiently, doesn't take appropriate measures, what does it cost?
Just that as I showed it in my PowerPoint. There's no cost when if the employer don't fulfill their obligation, and they just the only measure they just take is just fire the worker, and if the company sorry, we haven't do any actions.
Okay.
Yeah.
But this will be a cost as well, that it's made public and that your reputation is damaged or whatsoever.
Can I, if nobody else has a question, I know I've asked quite a few questions. I don't mean to abuse my privilege as the chair. And it's kind of relates, is a follow-on from Peter's first question or observation. Peter's question was about, you know, did you examine domestic violence and other types of sexual harassment outside the workplace? My question is, it's kind of related. It's about what kinds of settings are covered by the civil code and the legislation you mentioned. I understand workplaces. I mean, but additionally, there are a variety of other settings where you might anticipate that sexual harassment might take place. So just thinking of healthcare settings, say in a hospital where you have, you know, by definition almost, you have patients, say female patients who are sexually harassed by a doctor, let's say, or a male nurse, or other settings, I don't know, local government settings or party settings, a whole variety of other settings. So my question is does the code, is it narrowly focused on, or specifically focused on employer-employee workplace settings, or does it include other settings?
Oh, the civil code is not the 2021 civil code include all the types of sexual harassment, but it referred to the workplace sexual harassment. It besides the sexual harassment, it's especially referred to the workplace sexual harassment, but and also the school and also the sexual harassment take place in school.
Okay.
Yeah.
Thank you.
Thank you.
Okay, we're coming to the end of today's HRUG-Open session. I'm just checking if anybody has final last chance to ask a question or make a comment. Guo, you have explained everything so well that nobody has any further questions.
Thank you.
So it just remains for me to thank our guest presenter, Dr. Guo Min from the Law School in Central South University for her very interesting presentation today. Thank you for people who attended. This is Joe Finnerty from University College Cork in Ireland. So thanks to everybody for attending. Thanks again to Dr. Guo Min, and hopefully see you all next month.